Good evening, everyone. This is Clinton Poteet, and this is going to be my quiz review. So we're going to do question 3 on page 81 of your textbook under Research This. The text refers you to a case called Palsgraf versus Long Island Road Company from 1928. Look up that case. According to majority opinion, why did the plaintiff lose? So this was one of the questions that we basically had to take a stab in the dark at because due to what Ms. Johnson said, our prior instructor, it was not a part of the reading. It was from a prior book, so on and so forth. But I took a stab at it regardless, and despite us getting the points for it as promised per Ms. Johnson, I am going to just go ahead and review it and analyze it anyways. So, why, according to the majority opinion, why did the plaintiff lose? So again, this is going to be page 81, as can be seen right here. There is no case, period, right here. So we're just going to minimize this, go over here to Palsgraf. Now, I've already looked it up, but I'm going to go ahead and just look up or take you up to the top. Now, as you can see, this is the correct case, Palsgraf versus Long Island Road Company, May 29, 1928. So what we'll do is basically just go here to go to and the opinion. So this is going to be the majority opinion since it is not the dissenting opinion. If it's dissenting, it would say dissenting, before opinion. Now, all of this here basically states that, essentially the prerequisite before the opinion is given. So we jump down to 1 through 5. The conduct of the defendant's guard, if a wrong in its relation to the holder of the package, was not a wrong in its relation to the plaintiff standing far away. Relatively to her, it was not negligence at all. Nothing in the situation gave notice that the falling package had in its potency of peril to persons thus removed. Negligence is not actionable unless it involves the invasion of a legally protected interest, the violation of a right. Proof of negligence in the air, so to speak, will not do. Negligence is the absence of care according to the circumstances. Now, essentially, what that is stating, as well as the rest of this down here, all of this narrative, is that the road company did not owe a duty to the plaintiff. It goes on to state essentially that, as you can see, that the reasonably to be perceived defines the duty to be obeyed and risk imports relation. It is risk to another or to others within the range of apprehension. This does not mean, of course, that one who launches a destructive force is always relieved of liability if the force, though known to be destructive, pursues an unexpected path. It was not necessary that the defendant should have had notice of the particular method in which an accident would occur. Negligence and going down. Negligence, like risk, is thus a term of relation. Negligence is the abstract. Apart from things related, is surely not a tort, if indeed it is understandable at all. Now, essentially, what we're saying here is that the correct answer is going to be one of these 4 options. Now, her injuries were relatively insignificant. that's not for one to decide. If you've got injuries, then of course it's going to be significant. If it's not, if the Long Island Road Company is not liable for it, then the individual in question who owned the property, the package, fireworks, gun, whatever it may be, that would be, or that individual would be liable. Now, the railroad company did not know any duty to the plaintiff. That is not true. The railroad company did owe a duty to the plaintiff. The railroad company's breach did not cause the plaintiff's injuries. Now, that is what we're about to look at, and she was far too removed from the negligent act. Now, she wasn't far too removed from the negligent act in the sense that it wouldn't matter whatsoever. Now, that's neither here nor there. The answer that I believe to be true is the railroad company's breach did not cause the plaintiff's injuries. There's no real way for it to be put other than the railroad company did owe a duty to the plaintiff to protect the plaintiff, keep the plaintiff safe, but the breach regarding the individual in question who held the package that caused the injuries, that is not an issue for the railroad company. The railroad company did not cause that. The railroad company did not tell that individual to bring the package that would cause the injuries to the plaintiff on the railroad. That's essentially basically meaning that plaintiff was denied because the railroad company's breach did not cause the plaintiff's injuries. The individual who had the package caused the plaintiff's injuries.